Soon may the wellerman come to bring us sugar and tea and rum. One day when the stripping is done, I'll take my leave and go. Na 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 na. Okay, ahoy mateys! Welcome to the ship. I'm gonna call it the Special Needs Ship of Safety. I am a mother of a 41-year-old intellectually developmentally disabled man, and his day activity group announced to the world that they were going to start going to strip clubs every month, once a month and a night activity. So I called all the protective places, and they all told me it was just fine, just fine. So on my channel, I'm squeaking the wheel. And I had to go apply for guardianship, which I did, and there was a 20-day wait, which we did. And I've got my papers now. So I did, I don't know how much it costs yet. We haven't gotten our bill. We did guardianship, and we also did a trust. We went in and signed all the papers, and I learned that I have to do a class. Me and my husband both. We have to. It's an online class. So I'm planning on recording me doing the test. Let's all find out what it takes to be a guardian. And I wanted to read just the top part of this paper for now. I haven't even read through them all. But this is about the class, I think. Okay, duties of a guardian. A guardian is appointed to be responsible for and to promote and protect the well-being of a protected person. Oregon law imposes civil and criminal penalties for financial or physical abuse of a protected person. This document summarizes your duties as a guardian for a person whom a protective order has been issued. In certain counties, non-professional guardians are required to attend a training course. You must register for this training by February 13th. No later than 15 days. Following my appointment as a guardian, I register for an online class at www.guardianpartners.org or by telephone. The training must be completed by March 30th, 2026, no later than 60 days after the guardianship. Following your appointment as guardian, if you have any questions about specific rights or duties involved in the guardianship, please ask an attorney. Okay. The following list describes the general duties and responsibilities of a guardian after appointment by the court. Review the limited judgment appointing you for specifics on your authority and limitations as guardian. You must send notice of your appointment as guardian to the respondent and required notice parties. This notice must include your date of appointment, a description of your authority and limitations, blah, 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 blah. Oh, this is a lot of stuff. Okay, a lot of that I'm not going to read is about delivering notices to the person. And we're going to move on down to 3. Take custody of the protected person, which entails an element of control over the activities of that person, including, for instance, determining where the person lives. Number 4, provide for the safety, care, comfort, maintenance, and if necessary, the training and education of the protected person. Take reasonable care of the protected person's clothing, furniture, and personal effects. When appropriate, make healthcare decisions on behalf of the protected person, always seeking to carry out the known wishes of the protected person. If those wishes are not known, then seek to act in the best interest of the protected person. When appropriate, make funeral and burial arrangements in advance and control. We already have our plots. We've lost a few babies. If a conservator has been appointed for the protected person, work with the appointed conservator to see that the protected person has adequate funds to provide. Okay, we don't have anything to do with that. I guess that would be something different. A person could have a guardian and a conservator. They could be different people. And then I have to file an annual report to the court due each year 30 days after the anniversary of your appointment as guardian. The first report is due on March 1st, 2027. Mark my calendar for each anniversary. I send a copy of the report to the protected person, which he lives with me. They changed, it says, be aware that the form for guardians report changed as of January 1st, 2020. So it's important that you use the current form. Court approval is required before any payment can be made from the protected person's funds for any room and board provided to the protected person by you, your spouse, your parent, or your child. So I'm going to have to find out about that. And if we move, we have to notify the court. We don't plan on moving. Beginning on January 1st, 2020, a guardian is not allowed to limit a protected person's contact with their preferred associations unless specifically allowed by a court or if necessary to avoid unreasonable harm to the protected person's health, safety, or well-being. Let's read that again. Beginning January 1st, 2020, a guardian is not allowed to limit a protected person's contact with their preferred associations unless specifically allowed by a court or if necessary to avoid unreasonable harm to the protected person's health, safety, or well-being. So that's what I feel like I'm doing. I'm protecting them from unreasonable harm to their safety and their well-being. That's exactly what I feel like I'm doing. But it says a court has to specifically. I'm going to put this in ChatGPT. Let's see what ChatGPT has to say. I don't have my microphone hooked up on my phone. Could you help me understand this part of my guardianship papers about protecting your person you're taking care of? In the papers it says, beginning January 1st, 2020, a guardian is not allowed to limit a protected person's contact with their preferred associations unless specifically allowed by a court or if necessary to avoid unreasonable harm to the protected person's health, safety, or well-being. I would like to know how that works into the videos that I'm trying to advocate about the strip club incident and my son. All right, I'm going to go ahead and read the script. I don't know how this video is going to turn out. Okay, yes. Oh, you're welcome. Oh, did I even do my welcome for the date? Anyways, 4:20 a.m. Pirate time. Okay, yes, and this is an important nuanced part of guardianship law, so you're right to slow down and understand how it actually works in real life, not just on paper. I'll break this into plain English, and then how it applies to the strip club issue, and finally how to frame it accurately in your videos so your advocacy stays strong and credible. The key sentence is this: a guardian may not limit a protected person's contact with their preferred associations unless specifically allowed by a court or if necessary to avoid unreasonable harm to the protected person's health, safety, and well-being. This law was written to stop unnecessary isolation and control, not to remove safety. That does. Adults under guardianship still have the right to relationships. Guardians are not supposed to isolate or control someone just because it's easier. Preferred association means friends, romantic partners, family, social connections the people wants, social connections the person wants. This was a response to abuse by isolation, where guardians cut people off for their own good without justification. The exception is where my advocacy lives. The law then gives two very clear exceptions. A guardian can limit contact if a court specifically allows it, or it is necessary to avoid unreasonable harm to health, safety, or well-being. The phrase matters. That phrase matters. Unreasonable harm. This does not mean discomfort, disagreement, they like it. It does mean risk of sexual exploitation, risk of abuse, risk of coercion, risk the person cannot understand, report, or escape. Why strip clubs are not the same as preferred associations. This is the critical distinction that keeps getting ignored. A strip club is a commercial sexual environment designed for sexual arousal, operated by people paid to stimulate sexual interest, a setting where consent and boundaries are assumed, not protected. This is not the same as a friend, a boyfriend or a girlfriend, a social club, a family member. So when the state or providers frame this as, you can't limit preferred associations, they are misapplying the law. A venue is not an association. A paid sexual environment is not a relationship. How this connects to nonverbal or cognitively limited adults. This is where my son's situation becomes legally and ethically critical. If a person is nonverbal, cannot report abuse, cannot clearly refuse, cannot understand sexualized behavior, cannot distinguish performance from consent, then risk threshold is already crossed. Now my son can talk. He can talk, but he could never explain something like this. At that point, a guardian is not controlling. A guardian is preventing unreasonable harm. That is exactly what the law allows. In fact, failure to act could be argued as neglect of duty. Why dignity of risk does not override safety here? Dignity of risk applies when a person understands the risk, can say yes or no, can leave, can report harm. It does not apply when the person cannot consent meaningfully, the environment is inherently sexualized, and care providers are paid to supervise but claims to be hands-off. Risk without comprehension is not dignity, it's exposure, and they are exposing them to so many dangers in life that they have absolutely no protection from at this point. Okay, how to say this clearly in my videos without using credibility. Here's language that is accurate, powerful, and defensible. Guardianship law does not require me to expose my son to unreasonable harm. The same law that protects a person's right to relationships also gives guardians the authority and responsibility to prevent harm when a person cannot protect themselves. A strip club is not a relationship. It is a commercial sexual environment. Protecting my son from sexual exploitation is not isolation. It's guardianship, or shorter. This law was written to stop isolation, not to force guardians to allow sexualized environments that a person cannot understand, consent to, or report harm from. And from what I've been through, even people that do report harm, I'm not sure they'd get very far. Okay, the core contradiction that I'm exposing, and it's valid, the system is trying to say both of these things at once. You must protect vulnerable adults. You may not interfere with their choices, but they refuse to answer the real question. What happens when the person cannot understand the choice and cannot report the harm? My advocacy is not extreme. It's pointing out a legal and moral gap. Okay, now we're going to ask it, why would the state and paid care providers and the activity group. No, we'll do the ombudsman or the ombudsman say it's okay for them to go. Right. D-U-L-T. See what it says. Okay, it's going to be a hard truth. It's going to be a hard truth. It's going to be directly and honestly, not bureaucratic fluff, because what you're running into is system logic, not common sense. The short answer is they say it's their right as an adult because that framing protects the system, not the person. Okay, I'm going to do this all over again. Long pause. This is a hard truth, and I'm going to answer. This is a hard truth, and I'm going to answer you directly and honestly, not with bureaucratic fluff, because what you're running into is system logic, not common sense. The short answer is they say it's their right as an adult because that framing protects the system, not the person. Now let's unpack why, step by step, so you can see the machinery you're pushing against. The state defaults to adult rights because it limits liability. For the state, calling someone an adult making adult choices does three things at once. It shifts the responsibility off the state. If it's the individual's choice, then abuse becomes an individual incident, not a system failure. Oversight agencies aren't responsible for the outcomes. Providers aren't responsible unless there's a clear, provable force. Providers aren't responsible unless there's clear, provable force. And it protects Medicaid-funded providers. If providers are just supporting choices, they're not evaluating risk, screening environments, anticipating exploitation. That keeps staff cheap and training minimal. Avoids having to define cognitive capacity. Once the state admits some adults cannot meaningful consent, then they must then assess capacity, document risk, intervene. That costs money and creates accountability. So adults' rights become a legal shield. Ombudsman offices are structurally constrained. This part is especially painful but important to understand. The ombudsman is not a safety enforcer, obviously. They are complaint processors, policy interpreters, system stabilizers. They are not guardians, trauma evaluators, risk assessors, or risk assessors. Their job is to interpret the law in the least disruptive way to the system. So when you ask, what about nonverbal clients, and you're told they can push away or fight back, that's not a belief. It's a defensive script. Why? If they admit nonverbal people can't protect themselves, the entire choice-based model collapses. Every provider outing becomes a liability review. The state becomes exposed. So they lowered the standard of safety instead of raising the standard of care. This is what's happening right here. Rights language is being used as a substitute for protection. Here's the contradiction you've already spotted. The system says adults have the right to sexual expression. We respect autonomy. We don't judge preferences. But it refuses to ask, who benefits from this interpretation? Rights without capacity equals exposure. Rights without capacity equals exposure. When someone cannot consent, cannot report, cannot escape, cannot understand exploitation, then invoking rights without safeguards isn't empowerment. It's abandonment, dressed up as progress. Why paid providers repeat this line without questioning it? Most DSPs and administrators are not evil. They are boxed in. They are trained to follow the ISP, avoid restrictions, document choice, avoid using judgment. Because if they do question, they can be accused of violating rights, being paternalistic, overstepping authority. So they learn, if it says the client's choice, I'm safe. That's how moral responsibility gets outsourced to paperwork. Ooh, why my argument scares the system. You are not just saying this one thing is wrong. You are saying, I am not just saying this one thing is wrong. I am saying the entire framework fails when cognition and consent do not line up. This forces the system to confront sexual exploitation risk, false consent, performative autonomy, paid supervision without protection. And if they admit that, policies must change, money must be reallocated, oversight must increase, some activities must be restricted. So instead they repeat, they're adults, it's their right, because it's the simplest answer that keeps everything else intact. The sentence I can use to cut through the noise. This one lands and it's accurate. Calling someone an adult does not magically give them the ability to consent, report abuse, or protect themselves. When the system uses adult rights language to avoid providing adult-level protection, that's not dignity, it's neglect, or even sharper. If calling it a right removes the duty to protect, then it's not a right, it's a liability strategy. Or even sharper. If calling it a right removes the duty to protect, then it's not a right, it's a liability strategy. These people. The uncomfortable truth. The state and providers say it's okay because it's cheaper, it's defensible, it's consistent, it avoids hard questions. Not because it's safe, not because it's ethical, not because it protects people like my son. Okay, that's the whole script. But I shall persevere. Me and my ship will keep sailing. My ship of safety for special needs. So I'll make me a little safety sign for my boat. So that's the video for today. I'm going to be going over more of my guardianship. So if you want to learn how guardianship gets, how it's going on down here, stay tuned. I'm going to film myself doing the test. I hope they don't have something on there saying, it is illegal to film this test while you're taking it. I can't imagine it is. Maybe somebody else would like to know what the guardian test was like. All this stuff just introduces a lot more work into my life. More paperwork. More people to contact every month. More. I do it to keep my son safe. But I think this is ridiculous for us special needs parents to have to be going through this. How did it get to this place in the world? They have nonverbal kids. They have these kids that beat themselves up, smash in the walls, scream all day. Okay, so anyway, so we're getting somewhere on our guardianship stuff. And I really didn't need all this extra paperwork and stuff introduced into my life. It's a lot. It's a lot. And for me to not be respected at all, to be talked to the way I've been talked to, after all the years I've put in, like I said before, this is my career. This is my kid. This is what I've done my whole life. I've raised my kids. And I will not just give my son's soul to any Tom, Dick, and Harry that can pass a criminal history check, because as soon as they get a job in Oregon at the group homes, they'll never get a criminal history check. They can do whatever they want, whenever they want. They have a whole little home that they can take to strip clubs, teach them what to do, how you like to see them act. Do people not see where this goes? Do people just not see that? Uh, yeah, parents, hop on board. Join my special needs ship of safety. We may not know what we're doing, but we're doing it. Ahoy. See you on the seas.